Can your silence be used against you?
No, it can't. You often see in criminal trials where a person is under interview and the interview notes might be read out to the jury, but if the person invokes their right to silence and answers each question with no comment, no comment, no comment, that's not, the state are not entitled to draw any inferences from that. They can't say to the jury or to the judge that you can draw a negative inference because this person wouldn't answer any questions. A person may refuse to answer questions for any number of different reasons, but it doesn't mean that they're guilty. Maybe they're paranoid, possibly, or they're upset, or they're scared. And all these things have been shown over the centuries to be reasons why people don't answer questions. But it's not an inference of guilt, and nothing can be inferred from that.
Why is protection against self-incrimination important?
It's important because the government can't make you testify against yourself. You're not obliged to help the state make their case against you. They have to make the case against you. You shouldn't have to assist them in helping to prosecute you. That would be perverse. So it's there to protect people in society against the overwhelming power of the state, because the state in its totality is enormously powerful. And when the state moves against you, you are just one individual. And you as an individual cannot withstand the pressure of the state coming down on top of you. So that rule is there to protect you against the illegal use of state power, and it exists in every democracy.
What is actus reus?
The actus reus is the guilty act. That's the wrongdoing. In theft, it's stealing. In an assault charge, it's the punching of the person, causing the injury. In public order offences, it's brawling on the street. In offences where you're being charged with engaging in abusive conduct in public, it's shouting abusive obscenities. Drink driving, it's the act of being behind the wheel of a car, driving while intoxicated. That's the actus reus. In all those situations, except drink driving actually, mens rea, the intention to commit those offences is necessary. In drink driving, there is no necessity to prove that you intended to drink and drive.
How do judges think?
It's a really good question. I really don't know how they think. I think that if I had to guess, I would say that when you become a judge, you're removed from your previous position as a lawyer. You're no longer a lawyer. You're now a judge. And when you're a member of the judiciary, you're in a kind of an elite club of people. Access to that is restricted. And there's certain norms and behaviors that are expected of you once you're there. Once you're in that position, precedent really takes is a very big thing in their lives, because all of the people that went before them, you have to uphold that tradition of professionalism and to be part of an institution that's respected. So they have to really follow the code of the judiciary that has gone before them, stretching back over 200 or 300 years. And not to do stuff that would maybe bring the judiciary into disrepute.
What is the role of causation in criminal law?
That is to see whether or not the defendant's actions cause the injury complained of. A good case in point would be where there's a melee. There's someone on the ground who's being punched by 4 or 5 guys. And one guy punches him in the face, but he kind of skins him. That doesn't cause the injury, but the other 2 or 3 guys are now kicking him on the ground, and they cause substantial injuries to his face, broken bones and stuff like that. You who punched him, even though you skinned him, you could be guilty of assault, but your action didn't cause the broken bones. There's no causation between that action and the ultimate outcome. But for the other guys, there is. They kicked him in the face, and he got his jaw broken. So it's easier to establish causation for those guys than it is for the first guy who punched him.